Texas abortion laws took center stage this week in Austin, with a judge hearing a lawsuit brought by a group of women who say they could not get life-saving medical care while suffering severe complications with their pregnancies. Texas law prohibits most abortions, with an exception if the life of the mother is at risk. But the women and physicians suing say the language in the bill is too vague. Our Monica Madden joins us now. You were in court for both days this week. This was emotional.
Yeah, absolutely, Josh. It was really tense in there. There was one woman who was testifying saying that she was forced to give birth even though the doctor said that her child would die at about halfway through her pregnancy. So she knew this was a long time coming, but still had to carry her baby to term. When she was recalling everything that happened to her, she started throwing up at the witness stand just from recalling all of that trauma. So the judge then immediately called a recess. So it was very, very emotional in there. An OBGYN doctor, also part of the lawsuit, told the judge that she is just terrified to perform abortions, even if a mother's life is at risk, unless if there is an immediate emergency situation.
I've always tried to practice within the standards of care, but I also want to be a law-abiding citizen, and I don't want to risk my freedom, my livelihood, and I don't want to take a chance that I'm wrong.
State attorneys argue that these physicians are misguided, and they say that the law is very clear, and they're asking the judge to dismiss the lawsuit altogether. One doctor who testified for the state echoed that sentiment.
Unfortunately, I've seen doctors say that they can't intervene until there's an immediate risk. This is further demonstration that they have not read the law carefully.
And I want to read what the law says exactly. The abortion prohibition does not apply when the pregnant woman has a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death or poses a serious risk of substantial impairment of a major bodily function. So that's exactly what the law says, word for word, Josh.
Monica, during this hearing, experts for plaintiffs said this is what they have to, this issue is exactly what they have to deal with, the exact timing and what's considered risk, right?
Yeah, exactly. There was an ER physician who the plaintiffs brought as their expert witness, and he talked about the difference between a critical emergency situation and an emergent one. And there is a difference. When something is critical, think of a gunshot wound, for example, that is something where if doctors don't act immediately, that person will likely die. Whereas an emergent condition is something where they could become life-threatening, but you just don't know what the timing is. So that was the point of these physicians, is without clear guidance around how immediately threatening, if it could become life-threatening, these pregnancy complications, do they have to act once it gets to the point where it's so bad that a woman is seriously in that critical condition? And that's where there's the confusion.
All right, Monica, thank you very much.
Soaring temperatures across the state and a rising number of prisoners dying behind bars.
I'm scared. I haven't even been in here 3 minutes and I'm feeling my heart pounding.
But a bipartisan effort to help inmates and staff withered in the legislature. The hope for a revival next.